You're angry, you're hurt, you suffered injury as a result of a doctor's carelessness or even a hospital's carelessness, and now you're contemplating bringing a lawsuit for medical malpractice. But at the same time, you're also considering filing a claim with the New York State Department of Health. Can that help you in your medical malpractice matter? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. The answer is, it might, and let me explain. Any injured victim has the opportunity to file a complaint with the New York State Department of Health. Once the New York State Department of Health obtains the complaint, they have an obligation to investigate. And as part of their investigation, they're going to send somebody out to the hospital to question the various staff and the doctors who are involved in your care and treatment. Then they're going to reach certain conclusions about whether or not there were violations of the standard of care, whether there were violations from certain hospital protocol. And if it turns out that there were, they may issue what's known as a statement of deficiencies and require that the hospital prepare a corrective action plan in order to make sure that this type of thing doesn't happen again. Now, in your medical malpractice matter, can we use that information if they find that there are deficiencies and violations from the standard of care and protocols? Can we use that information at your trial? The answer is maybe. There are certain limited instances where we can use findings of fact by the Department of Health in your particular matter. Now, we have to show that we are more likely right than wrong, that the hospital or the staff departed from good and accepted care, that they violated the basic standards of good medical practice. And as part of that investigation that the Department of Health does, in limited instances, we can take certain findings of fact, taking testimony from the people who did that investigation, and teach the jury and explain what they did in order to help us show that we're more likely right than wrong. In all likelihood, we are not going to be able to use the conclusions reached by the Department of Health about the deficiencies and about the corrective action that they were required to take. So instead, that ultimately is the jury's finding. We have to bring in various medical experts to support our claim. And ultimately, it will be the jury's determination to decide whether or not the hospital and the staff violated the basic standards of good medical care. So why do I share this great information with you? I share it with you just to give you an insight and an understanding, because I realize that you're hurt, you're angry, you're upset, and you're contemplating bringing a lawsuit for medical malpractice, and at the same time you also want to do everything possible by filing a complaint with the New York State Department of Health. And if you do have questions, you can reach me at 516-487-8207 or by email at Gerry, Gerry, @oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.